learning.
All right, welcome to this explainer. If
And
you're a
keep
corporate
learning.
professional, a founder, or just someone trying to navigate the absolute maze of raising capital, well, you're in exactly the right place. Today, we're setting the stage to build a legally watertight capital raise without missing a single statutory detail. We're going to look at the exact step-by-step blueprint of a rights issue under the Companies Act 2013. Here's the exact chronological blueprint we'll be tackling today: the rights issue foundation, board approval and offer, timelines and the fast track, renunciation and FEMA rules, forms, certificates, and duty, and finally, valuation and tax implications. Let's get right to it.
Section 1. The Rights Issue Foundation, establishing the base.
So, a rights issue is governed primarily by Section 62 1A of the Companies Act 2013. But what does that actually mean in plain English? Simply put, if a company wants to issue new shares, it's legally required to first offer them to its existing equity shareholders, right, in proportion to what they already own. Think of it as a preemptive right. It's basically a shield that allows current shareholders to protect their exact percentage of ownership from getting diluted. If you own 10% of the company, boom, you have the absolute right to buy 10% of the new shares being issued. It's really that simple. Section 2. Board approval and offer, drafting the plan. Okay, so how do we actually get this off the ground? Well, it all begins with the board of directors. First up, you've got to issue a 7-day notice to convene a board meeting. During this meeting, the board passes a resolution, specifically under Section 179(3), to officially approve the rights issue. Now, this route is incredibly popular. Why? Because unlike a preferential allotment or a private placement, a standard rights issue absolutely does not require calling a general meeting to get shareholder approval. The board can execute this whole thing entirely on its own authority, which is a huge time saver. During this exact same step, the board is also going to draft and finalize the letter of offer, which is just the formal invitation that gets sent out to the shareholders. Section 3. Timelines and the fast track, accelerating the build. Let's be real, time is money, especially when you're raising capital. Normally, under Rule 12A of the company's rules, you're required to dispatch your notice at least 3 days before the issue opens, and then you have to keep the offer open somewhere between 7 and 30 days. But here is a massive fast-track loophole. If you're a private company and you can secure consent from 90% of your members, you can literally slash these mandatory waiting periods. You can reduce that pre-dispatch notice, and you can even keep the offer open for less than 7 days. For startups or companies needing an immediate capital injection, bypassing those strict waiting periods is an absolute game changer. Section 4. Renunciation and FEMA rules, modifications, and exceptions.
All right, but what happens when a shareholder doesn't actually want to buy the shares themselves, but maybe they know someone who does? This brings us to the right of renunciation under Section 62 11A2. When a shareholder gets that offer for rights shares, they don't just have to say a simple yes or no. They can actually say, hey, I'm passing these rights on to someone else. And the beauty of this mechanism is that it's an automatic right, unless your company's articles of association expressly prohibit it. Plus, and this is a really key point, renouncing your shares to a third party who isn't currently a member doesn't magically transform your rights issue into a heavily regulated public offer. It's simply a transfer of your existing entitlement, nothing more.
But wait a second, what if that third party happens to live outside the country? This is exactly where our architectural blueprint needs a giant flashing compliance warning sign. What actually happens when shares are renounced to a non-resident? Well, this is exactly where corporate law forcefully collides with the Foreign Exchange Management Act, or FEMA. The second you bring a non-resident into the mix, you immediately trigger FEMA Rule 7 under the Non-Debt Instruments, or NDI rules. Suddenly, you can't just issue those shares at whatever price you feel like. You absolutely must adhere to strict, internationally recognized pricing guidelines, and you have to meticulously check sectoral caps for foreign investment. Crucially, and you really don't want to miss this, once those shares are allotted to the non-resident, you've got exactly 30 days to file Form FCGPR via the RBI's firms portal. Miss that deadline, and you are staring down some very severe FEMA contraventions. Section 5. Forms, certificates, and duty, the final inspection. So, the money is safely in the bank and the board has officially approved the allotment. Now comes the paperwork. Here is your mandatory post-allotment compliance checklist. First off, Form MGT-14. This must be filed within 30 days of your board resolution to officially register the board's decision. Second, and arguably most importantly, is Form PAS-3, which is the return of allotment. You have exactly 30 days from the actual date the shares are allotted to file this specific form with the Register of Companies, and it needs to be complete with the full list of every single allottee. But don't pack up just yet. We aren't done. You are legally required to actually issue the SH1 share certificate to these new shareholders, and you have to do this within 2 months of the allotment date. And inextricably tied directly to that physical certificate is your state-level stamp duty. That duty generally has to be paid within 30 days of issuing those SH1 certificates. Do not forget that step. To put it all together, here is your precise compliance countdown clock. Think of day 0 as your allotment date. By day 30, your PAS-3 and MGT-14 filings are absolutely due. Boom. By month 2, those SH1 certificates must be issued. And then, within 30 days of that issuance, the stamp duty has to be fully paid. I highly recommend internalizing these deadlines, guys. It's really the only way to avoid those hefty late fees and absolutely massive regulatory headaches down the line. Section 6. Valuation and tax implications. Passing the audit.
Okay, we are now entering the final, and let's be honest, often the most intimidating phase of our blueprint, the audit, valuation, and tax. I want to address a massive misconception here, one that frequently delays funding rounds and ends up costing founders an absolute fortune. The question is, do you always need a formal valuation report from a merchant banker or a CA to do a rights issue? The answer is a definitive, resounding no. Listen to this. For a purely domestic, pro rata rights issue going to resident shareholders, neither the Companies Act nor FEMA requires a formal valuation report. None. You can literally issue shares at face value or at a premium determined strictly by the board without paying thousands for a complex, discounted cash flow valuation. Honestly, this is a massive, massive compliance relief for so many companies. However, you knew there was a however, right? This brings up the absolutely dreaded deemed gift tax under Section 56(2)(x) of the Income Tax Act. Now, this specific section terrifies corporate professionals, and for good reason, because if you receive shares for less than their fair market value, the income tax department can swoop in and tax that difference as income from other sources. So the big fear is, does this tax trap suddenly snap shut on your shareholders during a discounted rights issue? Well, here is the incredible legal relief. Pro rata rights issues actually generally avoid the Section 56(2)(x) tax trap entirely. Why? How is that possible? Well, because if the issue is strictly proportionate across the board, there's technically no transfer of property without consideration. The total pie, the value of the company, remains exactly the same. You are merely apportioning that existing intrinsic value over a larger number of shares. It's a proportional split, so the taxman usually backs off. But, and please hear me out because this is a massive caveat, the literal second you break that exact pro rata ratio, your tax shield drops completely. If the board decides to allot unsubscribed shares disproportionately, or if a shareholder renounces their rights to a third party at a ridiculously low price, yeah, Section 56(2)(x) can absolutely be triggered. And let me tell you, that can result in some genuinely severe tax penalties for everyone involved. And just like that, our structural blueprint is complete. We've navigated from Section 621A, preemptive rights, all the way through the MGT-14 and PS3 filings, SH1 certificates, and right past those incredibly tricky Section 56(2)(x) tax traps. Yes, the rules are extremely intricate, but as you've seen, they're completely manageable when you just take them step by step. So keep these strict timelines and exceptions in your back pocket, and let me leave you with this final thought. With this roadmap in hand, are you truly ready to execute your next capital raise flawlessly? Thanks so much for joining me for this explainer.